So yes, Jefferson and Marshall are cousins. Jefferson did not like Marshall, not only politically, but personally. He famously called John Marshall that gloomy malignity, and Lincoln ignores it. He just ignores Taney, and he says, look, I am the commander in chief. I am suspending the writ of habeas corpus, even though Article 1 says that Congress can do that when there's a rebellion. But he's doing it because there's a rebellion, even though the president doesn't have that explicit power given to him.
Dr. Perry, it's a pleasure to have you on our program. Thank you for taking the time for this conversation with me.
Oh, great to be with you, Adele.
As I was preparing to speak with you about the relationship of our presidents and our Supreme Court, I was jotting down notes, sort of questions to ask you. And I realized something interesting. I didn't really have many questions to ask you kind of about the first decade of our republic. Did I miss something? Are there anything big points of conflict between President Washington and President Adams and the Supreme Court?
Not as such. So I wouldn't say you missed anything terribly important, but there are just a few things to note. One is that as the Constitution that is ratified in 1789 and the new government gets up and running from that point onward, we do have these three branches of government. Most people learn in civics or a government class or a history class. And given what's happening in Washington these days, it's especially important to note that there are three branches of government and that the basic foundations of the founders who wrote the Constitution, our second Constitution, the Articles of Confederation, that was failing. And so they gathered in 1787 in Philadelphia. Some thought they were coming merely to rewrite or revise the Articles of Confederation, but James Madison, from where I am here in Virginia, I'm sitting in Charlottesville, the home of Thomas Jefferson, up the road 30 miles from Orange, Virginia, Madison. It's just amazing to me. Was there something in the water of this Commonwealth of Virginia that caused these brilliant minds to develop? And in the case of Madison, took the lead, thought we need an entirely new constitution based on separation of powers among those three branches and checks and balances of one against the other. So that's our starting point. And that Washington believed so strongly in the Constitution. There were some founders who, even those who met in Philadelphia, who again thought they were just coming to revise the articles and wanted to keep most of the power in the states. So Washington was careful to try to choose, first of all, men who had only men, I'm sad to say, but men who had supported the revolution, and then men who had supported the Constitution of 1787 coming out of Philadelphia and then ratified in 1789. And it had only 5 members, the court did in those days. So only 5 members rather than the 9 that we're used to. That number goes back to 1869, and Congress can change that up or down. We've had as many as 10 over the years in the Civil War period and as few as 5. So that's how Washington viewed the importance of that body. The other important thing is he's replaced, as we know, after 2 terms, although he could have stayed on and been elected, no doubt, to a 3rd or 4th term. Sadly, he died not too long after stepping out of the presidency after 2 terms, setting that precedent of 2 terms until the Constitution amends it to a definite 2-term only.
Because of FDR, whom we'll talk about.
Yeah, shortly. Exactly. Yes. So in any event, Washington leaves after 2 terms. In comes John Adams, who is a staunch Federalist, meaning very strongly for national power. And still from that time of the founding, from the time of writing that Constitution, first our Constitution of the Articles, then the Constitution of 1787, you have this split among the framers that some are more interested in keeping power in the states close to the people, and others think in order to have a strong country, you have to have a strong national government. And John Adams, is one of those. So as he is defeated by Thomas Jefferson in 1800, a very vitriolic election, we thought Bush v. Gore was nasty, or we thought, Trump versus Hillary was nasty. Things were pretty nasty back there in 1800 because Jefferson was a states-oriented Jeffersonian party, or they were called the Democratic Republicans, not to confuse us about modern parties, but really the forerunner of the Democratic Party. So you have those two men go at it. Jefferson wins in 1800. Adams is tossed out after one term, but before he leaves, he tries to pack the Supreme Court and the lower federal courts with what they call midnight judges. That is, as he's practically walking out of the White House, he's signing these commissions to get these Federalists on the federal courts. And the most important one he places as the Chief Justice of the United States, John Marshall, the ultimate Federalist, pro-national government, pro-power of the national government. And he serves there from 1801 to 1835. So it really
that's a long time.
It is a long time. He's the fourth longest serving justice. He's the fourth Chief Justice, but he's known among historians and political scientists like myself and people at the court, where I had the pleasure and the honor of serving as a fellow in the mid-90s. We call him the Great Chief Justice because he was the greatest Chief Justice. And there's a massive statue of him on the ground floor of the current Supreme Court building. So that's what we should take from the earliest years of the court. And it also sets up a battle as we come up to Jefferson as a states-oriented president. And by the way, one who believed in what theorists call the coordinate theory of the branches of government, which meant that because Jefferson was always fearful of power being concentrated, he didn't want any of the branches really to be able to overcome another branch. So he said each of the three branches can determine what is constitutional or not. Well, that's not where Marshall went with the famous Marbury versus Madison case in 1803.
Okay, so let's talk about this battle. Jefferson becomes president, and correct me if I'm wrong, John Marshall happens to be his real life first cousin?
They are, I've read all sorts of different, first of all, they are cousins, so they are related. But I've read all sorts of different records that it's first cousin once removed, it's second cousin, it's third cousin. So not being a genealogy expert, I will just say they are cousins at some level in their family tree. But they were political rivals. They were political.
Big time.
Big time is the word, because again, Marshall was for very powerful national government, a powerful and equal branch who could say to the other branches, the legislature, Congress, or the president, you've done something that's unconstitutional. That is, if a case came to him. And that's important for people to know. The court has to wait for cases to work their way up, either through the federal system, in the modern era, district courts, courts of appeals, and then the court, if it hears an appeal or gets an appeal, it can decide whether it wants to hear it. It can also choose to take cases on appeal from the highest state courts. So that is a bit of a limitation, to be sure. It can't just look out at the Congress or the president or a governor or a police officer in the street and say, oh, we think you've done something unconstitutional. It has to wait for that process of the judicial process to work. So yes, Jefferson and Marshall are cousins. Jefferson did not like Marshall, not only politically, but personally. He famously called John Marshall that gloomy malignity, which I have a hard time understanding, because I have visited and taken teachers to both Monticello here in Charlottesville, where Madison and Jefferson would gather together, and Jefferson would continue his architectural work, and he would meet people like Lafayette, and all sorts of people came to visit him there, not only from Virginia but around the world. And Marshall was from Richmond, or lived in Richmond. He was born in Warrenton, up the road here from me.
Which is a bigger city, it's an urban area even back then.
Yeah, exactly. And he struck me, even though we think of Jefferson as being a Renaissance man, and he was, and that he was an expert in so many things, but he was a little bit on the I would say the serious side. I mean, he did like music and he liked literature, but and he loved having his grandchildren around him. But when you see Monticello today, as they believe it was in Jefferson's time, it's a pretty serious place. It feels like a museum. Whereas when you go to John Marshall's home that he lived in Richmond when he wasn't in Washington meeting with the court, there's a certain gaiety around it, and there are tables with games on them, and apparently he was a bon vivant in Richmond at the time. So I don't ever see him as gloomy, and I should also say I think he's one of the most handsome ever to serve on the court. So people should. Obviously, there are no photographs, but people should look up his painting. I'd say he would be a movie star today.
Wow, that's great to hear. I mean, that's like sort of the inside story of our Supreme
Things
Court.
You don't normally hear about John Marshall.
And I've seen portraits of him, and I actually, one of my guests, Professor Paul, actually wrote a book about him, and we talked about him. So it's a bit of an irony that Jefferson would call Marshall gloomy. If anything, it should be the other way around.
Yes.
So let's go to the first big battle, legal battle, or I guess turf battle between the President Jefferson, and the Supreme Court. When does that happen?
Right. This happens in 1803. Jefferson is inaugurated. At the time, inaugurations took place in March. So he's inaugurated in 1801. And so he's two years into his what would be 2 terms. And he is upset about certainly the fact that Marshall is there as the Chief Justice. And a situation comes along that is related to the Judiciary Act of 1789. And this was one of the first pieces, maybe the first piece of legislation that's passed by Congress regarding the federal judiciary. Because mind you, Article 3 is the shortest of the constitutional structures of Congress. Article 1, very long, spells out lots of powers and authorities. Article 2, slightly shorter, but spells out a number of powers and duties and authorities of the president. And Article 3 almost looks like an afterthought. It's a very short article, and it establishes only the Supreme Court. And then it says other inferior courts. By that, they meant lower courts that Congress would set up. So Congress gets to work busily, and they set up a set of courts. The U.S. district courts, as we know them today, are the trial courts. The courts.
You're explaining the Judiciary Act of 1789.
1789, exactly.
Yes. Okay.
And they don't set up freestanding appellate courts that we now know as courts of appeals. What they do is they say that members of the Supreme Court will be assigned to what we now call circuits. That still exists. And then they say they and some district court judges, on a case-by-case basis, will sit when a case is appealed from a district court to this court of appeals. And that is the situation until the 1880s, when Congress creates freestanding courts of appeals with judges who are appointed to those courts of appeals. You still have Supreme Court justices who are assigned to these circuits for various duties. But let's go back to 1789.
So, Dr. Perry, based on what you were saying, so our appellate system back then was a combination of lower, inferior district courts and some Supreme Court justices getting together and hearing appeals.
Exactly. What
a different country that was.
Yeah, very different.
Okay.
So Mr. Marbury was one of those midnight appointments of Adams as he leaves office in 1801. Okay. It's not for a Supreme Court justiceship or a district court justiceship. It's for a justice of the peace position in Washington, D.C. Now, remember, Washington, D.C. has almost no home rule. It still is an entity of Congress today, but it does have a mayor, and it has some powers, and it even has some local courts. But at the time, Adams appointed Marbury, a Federalist, named him to be a justice of the peace in Washington, D.C. And he never got his commission that was signed by Adams Now, here's an interesting fun fact. It was John Marshall, the Secretary of State of the Adams administration, who was supposed to deliver the commission to William Marbury, but he was too busy leaving his position as Secretary of State to go be the Chief Justice of the United States. And in fact, you pointed out in your outline to me, he even overlapped in those offices for about a month. I mean, obviously,
he was
things were very
Secretary of
different
State
in those
Chief
days. So, according to the Judiciary Act of 1789, there is a original jurisdiction that's given to the Supreme Court. That is, it doesn't have to hear this on appeal, but it is to send out what is called a writ, and a Latin term of mandamus. Think of mand, M-A-N-D, command. And a writ of mandamus is an order from a court to an official to do his duty, to do what is called his non-discretionary duty. In other words, you don't get to say whether you get to do this duty. You are assigned to do this duty, and we, the court, are telling you to do it. And so Marbury was asking Jefferson's new Secretary of State, James Madison, to deliver his commission from Adams to Marbury to let him be a justice of the peace. Okay. All right. Now, this is where my students would always get really confused. And I agree that there are a lot of details, and we'll just kind of cut to the chase eventually. So don't get too buried in the rabbit hole of details.
All right.
But the case is going to the Chief Justice and the Associate Justices because they've been given by the Congress in the Judiciary Act of 1789 the original jurisdiction to issue a writ of mandamus. So Marbury thinks, great, this is wonderful. Of course, Marshall wants to give him his commission, or at least order Madison to do it, because he's a Federalist. Adams was a Federalist. Marbury is a Federalist. And what better way to poke Jefferson and Madison in the eye but to say, ha, 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 ha.
Yeah,
I have the power of original jurisdiction to issue a writ of mandamus because the Congress gave that to us, the Supreme Court, under our original jurisdiction. Here is the amazing wit and understanding and strategery, as the Bush 43 people would say, the strategy, the strategic mind of John Marshall. John Marshall says, oh, I would love to issue a writ of mandamus, but I can't do that. Even though Congress has given me and the court the power to do that, because our original jurisdiction is outlined explicitly in Article 3 of the Constitution, and writ of mandamus is not there. And how can you change the Constitution? What's the only way to change the Constitution?
Well, you amend the Constitution, right?
Exactly, Adele. So he says, oh, I'm so sorry, Mr. Marbury. I'm paraphrasing, of course. It's all very formal in an opinion issued by Chief Justice Marshall. I'm so sorry, Mr. Marbury. Much as I would like to, I can't issue a writ of mandamus to Madison to cause him and force him to do his non-discretionary ministerial duty and give you your commission because, dun, da, 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 that part of the Judiciary Act of 1789 is unconstitutional.
Wait.
It attempted to change the original jurisdiction of the Supreme Court and add to it. But that original jurisdiction, which is very narrow, is in the third article of the Constitution. As you just said, the only way to add or subtract to the original jurisdiction of the court is by a constitutional amendment. Appellate jurisdiction of the Supreme Court can be changed by Congress. So, but the important thing to remember is this is the first time the Supreme Court, which has been in existence since 1789, it's now 1803, but it's never struck down an act of the president or an act of Congress. It's the first time it ever strikes down an act of Congress because, according to Marshall, it is the duty of the court to say what the law is. And that comes to be called judicial review.
Wait a moment, please, Dr. Perry. No,
Okay.
this is really important because just 3-4 minutes ago, you used another principle, coordinate theory. Did I say that correctly?
Yes.
And
Yes.
that's Jefferson. He's saying every branch of the government can interpret the Constitution, the law for itself. With this clever decision, Marshall says, no, we, the court system of America, do that. So on its face,
for the other branches. And so, in other words, in taking on this power of judicial review, which is not explicitly spelled out in the Constitution, and it's sure not in Article 3, and it's not given to the court, it's not prevented anywhere explicitly that the court should not have judicial review. Now, wait, let me just say this. Article 6 of the Constitution has a supremacy clause, and it says the Constitution and the articles and the treaties, sorry, let me back up. Article 6, the supremacy clause says the Constitution and the laws and the treaties made under it are the supreme law of the land. And so what Marshall does is say, in Marbury, it is the duty of this court to say what the law means. He not only means what the Constitution means, but what laws that are passed by Congress mean. And as time goes on, that power of judicial review can also interpret and either uphold or strike down actions of the president. And because the Constitution is supreme over the states, it can strike down an act of a governor of a state, a legislature of a state, a mayor of a city, a police officer's action in the street. If someone is acted upon by a police officer and believes that action violates the U.S. Bill of Rights, can take a case all the way to the Supreme Court. And by the way, this has happened case by case, particularly through the 20th century, particularly in the Warren Court, which was known to support criminal rights. And by the way, the Bill of Rights, the 4th through the 8th Amendments are all about criminal rights, establishing the rights of criminals vis-a-vis the national government. But the court, in addition to applying those to local and state officials, also then incorporates the Bill of Rights and begins point by point, the Bill of Rights, apply them to state actions by police officers, by mayors, by governors, by state legislatures.
So,
and let me just give an example of that. Everybody knows Miranda rights.
Of course. And
right?
that came...
If you watch cop shows, legal shows, name them with me. Adele, you have the right to remain silent. Anything you say, if you choose not to be silent, anything you say can and be will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be supplied to you. That is the Miranda rights by the name of a man, a criminal called Ernesto Miranda. In the 1960s, the court develops under Earl Warren the Miranda rights. And I had a colleague here at UVA Law School who was a lawyer in Austria, and he came to do a master's degree at UVA Law. And he told me this funny story. He was representing a criminal in Austria, and the criminal said to my friend Helgar Schneider, he said, what about my Miranda rights? And Helgar, the Austrian lawyer, had to say, I'm sorry, those are only good in America. Here in Austria, we don't have Miranda rights.
That's a great story.
The power of popular culture in America, around the world.
So in the popular culture, probably at that time, this may have sounded like a win for Jefferson because the court didn't give Marbury his commission. But in reality, this was a huge case for the court. The court wins this big battle with the president.
You are way smarter than my students, because when they would brief cases in history, what were the facts, as I gave them in Marbury, what was the question that came to the court, What was the court's ruling? Yes or no for this party or the other? What was the summary of the opinion? And the last point was always, what was the significance of this case for the court, for American history, for the other branches of government? And you nailed it.
Yeah. By the way, I obviously I recall Miranda rights from law school days, but they don't say that anymore.
Oh, they tend not to call them that, but you know that you hear them say that they're all that's what we know them as. Those of us who study Miranda versus Arizona from what 1966. Yeah, I've had this idea that I'm fascinated by the Kennedy family and President Kennedy and sadly the assassination, and that what if Oswald hadn't been killed by Jack Ruby in Dallas 2 days after the assassination of President Kennedy, and that it ended up being Oswald rights.
Oh,
because if you ever watch any of the videos of Oswald being paraded through the Dallas Police Department with all these members of the media asking him questions, no, have you been charged with murdering the president? No, I haven't heard that. What's that bruise on your head? A police officer hit me. You know, he was not being, he did get a lawyer, I think, eventually, but he wasn't read Miranda rights. There were some
interesting.
In 1963.
Let's talk about the end of the dynasty that you alluded to, the Virginia presidential dynasty. We had Washington, Adams was an exception, but we have Madison, Monroe, and then, well, John Quincy Adams is not from there, but he sort of follows that founders, the elite class. Right. Now we have a political sea change, and it's Jackson. He brings a whole new wave of, for sake of being simple, populism, populist politics to America. How does Jackson get along with the Supreme Court? He's got a lot of new things that he wants to change.
Well, in a word, he doesn't get along with them until 1835 at 36, when John Marshall dies in office, and because chief justices and associate justices, according to Article 3, serve, as well as all other federal judges, for good behavior. And the only way to remove them is if they engage in bad behavior and can be impeached and convicted. So basically, they have life tenure if they don't want to retire. Obviously, then nature takes its course. Yeah. So until Marshall died and Jackson was able to put a like-minded chief justice for him on the court, and it was Roger Taney, also the first Roman Catholic appointed to the Supreme Court of the United States. He was by this time, we're calling them states' rightists. This is pre-Civil War, and the Civil War is fought over states' rights versus federal rights or national rights. So Marshall and Jackson don't get along. And famously, in the case of Worcester v. Georgia, involving very complex, and no need to go into all depth of the facts in the case, but the outcome is that John Marshall rules in favor of the federal government and how it deals with the Cherokee Nation and the tribe of Cherokees, who had a lot of land in their native land in Georgia. And Marshall decides in favor of the national government and its work with and treatment of the Cherokee, to say that the Cherokee are a sovereign tribe, and that only as a sovereign tribe or even nation, some might say, it's only the national government that can deal with them, not the state, in this case, not Georgia. And so famously or infamously, and probably apocryphally, it is said that Jackson, when he heard that Marshall had rendered this decision that was oriented towards national power rather than state power, was said to have said, "John Marshall has made his decision, now let him enforce it." There really was no order. There was no order to Jackson to do anything. It was, again, just an interpretation of how the national government could operate vis-a-vis the Cherokee sovereign nation, which we still view the Native American indigenous nations in this country and their reservations as sovereign entities. It did not prevent Jackson then from engaging in the so-called Trail of Tears.
Yeah.
And that is moving the Cherokee from Georgia to Oklahoma, and called the Trail of Tears because so many members of that tribe perished along that terrible route from Georgia to Oklahoma, uprooting these indigenous people from their lands. And
Both
so
Jackson and Van Buren carried that out. Yeah.
exactly, through the so-called Indian Removal Act.
Mm-hmm.
So as soon as he had the opportunity, Jackson replaced the now deceased marshal with Roger Taney. And the height, I would say, or some might call it the nadir, but the height of states' rights and as it turned out, pro-South and pro-slavery comes in 1857. Taney is still on the bench. So he's been there now 20 years. He's still on the bench. And the famous case of Dred Scott comes to the court. All right. And that 1857 ruling by Taney, as a states' rightist, argues that Black people in the United States are not citizens of the United States, and they are not free if they have formerly been enslaved and are taken to a free state. So people need to remember, we had states where slavery was banned and we had states where slavery was legal. And we tried to keep those even numbered as they came into the Union, because each side knew if there were more slave states than free states, then the slave states would have at least one state up on them and vice versa. So this was an ongoing struggle that had led to things like the Compromise of 1850 that my fellow Kentuckian Henry Clay had helped get through the Congress, the Missouri Compromise of 1850. Yeah. So, you've got this problem that's going to lead to the Civil War, but it really leads to the Civil War in 1857, when not only does Roger Taney say the court's decision for poor Dred Scott is, we know that you were taken by your master to a free state and you stayed there, but that doesn't make you free. And moreover, you and all of your fellow Blacks in the country are not citizens of the United States. That becomes very critical in Lincoln's eventual run as a part of the new party of the Republicans that are anti-slave and pro-union. He criticizes in the Lincoln-Douglas debates. He criticizes directly Taney and the court, and he even criticizes the court and its Dred Scott decision in his first inaugural address. So it takes the Civil War to settle this dispute, this horrible dispute in this country. And it takes the 14th Amendment at issue today about birthright citizenship to establish that all people born or naturalized in the United States are citizens of the United States.
So Lincoln takes issue with the Dred Scott decision, and rightfully so. And this is as in his famous debates with Douglas. And then he becomes president. He takes office on April 4th, 1861. Does he have issues with the Supreme Court?
He does, because he has seen not to use a pun, but the dreadful decisions that have come after. So let me back up. Lincoln has seen the dreadful decisions that have come out of the Supreme Court that are leading to this, what will be a civil war. As soon as Lincoln is elected, you have the beginning of the secession movement. So you have eventually 11 states of the Confederacy secede from the Union and form their own country within the bounds of the old United States as the Confederate States of America, or CSA. But once this rebellion begins, there continues to be a conflict between Lincoln and the Supreme Court, because he's still got Taney as the Chief Justice. And what happens is, as the rebellion begins, and there are all sorts of espionage and spying going on, and in the rebellion, there is the kind of espionage of breaking up railroad tracks and tearing down telegraph wires on the part of these Southern secessionists. And it's not as though we have an enemy in Europe or an enemy in the Far East or an enemy in Cuba we're fighting. this is the first time, other than pioneers and those on westward expansion fighting indigenous people, it's the first time we have a country of its own fighting us since 1812 in our own soil, when the British and the War of 1812 begins. So we've got this war within our own setting, our own boundaries, with people who had just been our own countrymen. And it's hard to find them. They're engaging some in the case of terrorists, not in any kind of uniform until a bit later. So one thing then that Reagan does is that's Reagan. I did a program on him yesterday. One thing that Lincoln does is he suspends the right to have a writ of habeas corpus. Here we are with Latin again.
Yeah.
Corpus, people usually understand as meaning the body. Habeas corpus, you have the body. A writ, again, an order coming from a court to a jailer to say, why do you have the body of that person in jail behind bars? And so if you are rounded up and put in jail, in our system, typically under the Constitution, you have to be told what is the beef against you, what is the law you have broken or are alleged to have broken that has caused a police official to put you in jail. You have to have that understanding so that your lawyer can begin, once we get Miranda rights and you get a lawyer assigned to you or you hire a lawyer, can fight for you. So Lincoln says, I am suspending the writ of habeas corpus in these areas of rebellion because we can't have people tearing down our telegraph wires and ripping up our railroad tracks, engaging in all sorts of sabotage in this new rebellion that's happening against us. We don't have that luxury of having the writ of habeas corpus maintained. We're just going to have to round these people up. And there is a conflict then between the Chief Justice of the United States, who is assigned to the circuit where this espionage is happening, and it includes Maryland, where by the way, Taney was from Maryland.
Yeah.
So he's sitting as a circuit court judge rather than as a Supreme Court justice. He's sitting as a Supreme Court justice as he is sitting on the circuit court, and he decides in favor of Mr. Merriman. And the case is called Ex parte Merriman, in behalf of Merriman. And Mr. Merriman has been thrown in jail as engaging in espionage and rebellion against the United States. And Lincoln ignores it. He just ignores Taney. And he says, look, I am the commander in chief. I am suspending the writ of habeas corpus, even though Article 1 says that Congress can do that when there's a rebellion. But he's doing it because there's a rebellion, even though the president doesn't have that explicit power given to him. And Lincoln then was famous for saying, should I go ahead and follow I'm paraphrasing here, jot and tittle of the Constitution and lose the Civil War to the Confederacy, in which case we won't have a union and we won't have a Constitution? Very interesting argument to make, which is why it wasn't certain that Lincoln would be reelected in 1864. There were so many issues related to his taking on this, what's called prerogative power, comes out of John Locke in the 1600s, actually around the English Civil War. And he had written in his political theory books that the king, at that time, the king had prerogative power, the prerogative to act in a crisis in the absence of law or against the law in order to save the country. And this was used by Lincoln as a reasoning. We're in a civil war. And again, this very logical Lincoln-esque, who was a lawyer, Lincoln-esque view of, my logic is, okay, you want me to wait for Congress to do that. And we might lose this rebellion, we might lose this civil war, and there will be no union and there will be no Constitution. So he acted not only in the absence of a power assigned to him, he acted against Article 1's assigning of that power to the Congress.
Yet he's one of our greatest presidents, but we overlook some of the things that could have fundamentally changed our democracy had it been a diabolical, a bad intention person. Um, there's so much to talk about here, but I'm really interested in speaking with you, Dr. Perry, about another big moment in America's history.
Yes.
It's nothing like President Jackson's populism, but similar to President Jackson, from my perspective, FDR, Delano Franklin Roosevelt, also brings a sea change. Many of the things he does, after Hoover is kicked out, loses the election, are really new to the American way of life and also economy. So let's talk about that. How does the New Deal shape a big conflict between FDR and the court?
Right. Well, first of all, thank you for drawing that historical link and parallel. Two Democrats, Jackson and Franklin Roosevelt, who are populist in the sense that they are supporting the common man and woman. And even though in the case of Jackson, who is a man of the people,
Yeah.
a frontiersman, a general who becomes a celebrity during the War of 1812, but he expands the electorate. He lets white men who aren't propertied vote, and that's called the expansion of democracy or Jacksonian democracy. In the case of Franklin Roosevelt was elite. He was of the elite Roosevelts of Hyde Park.
Yeah.
But he had, maybe because of his polio, we may never know all the reasons, but his wife, Eleanor, a great American in her own right as First Lady, but
Yeah.
She said that she thought Franklin took on a different perspective about people and their problems because of his contraction of polio in his 30s that caused him to lose the use of his legs. So he was paralyzed from the waist down from that point on. And so I think his understanding of the suffering of the American people as a result of the Great Depression, which begins with the stock market crash in 1929 and is carrying through this term of office of Herbert Hoover, who's a conservative Republican and is not interested in using the powers of the national government to ameliorate the effects of the Great Depression, where you have, for example, 25% unemployment rate by the time Franklin Roosevelt is elected. And that's part of the reason he is elected in 1932.
Yeah.
And he's elected by a big majority. He takes office in March of 33. That's the last time a president is inaugurated in March. We back that up to January from the next time he's inaugurated onward. And he has massive majorities in the House and the Senate. And he has famously then that we now look at every president's first 100 days. And Roosevelt, with what is called his brain trust, with the smartest people in the country, coming from Harvard Law and other places of academic achievement and elitism, to be honest, figure out what is the legislation we need. Some executive orders, but primarily what legislation do we need to get through Congress to help the American people, to regulate businesses, to regulate agriculture, to regulate farms, and to help people. People had lost their homes, including my dad's own family. He was just a youngster, and his dad lost his job not long after the stock market crashed, and his dad would not have a regular job until 1936.
Wow. And this is in Kentucky?
This is in Kentucky. Actually, they were living in Ohio when my grandfather lost his job with the National Cash Register Company in Dayton, Ohio. And they moved back to their home of Northern Kentucky. And they just had to live with my dad's grandparents. And my dad was about 10 or 11. He had a paper route, and they lived off of his paper route. I think he made $9 a month.
Wow.
And so it was a horrible trauma for, as you can imagine, his parents, the grandparents, my dad, that I'm not sure he ever recovered from, in the sense of just being out on the street and getting food from the local, what we would call a food bank now. That just like go downtown and get some food and bring it home because we don't have enough money to buy food.
And Dr. Perry, this is before we had any welfare programs.
Exactly. It
Yeah,
was
yeah,
left up to cities and
yeah.
churches and charitable organizations, and they couldn't handle the expanse of the poverty, of the homelessness, of starvation, by the way, in addition to all the economic collapse, and it's a worldwide depression and financial collapse, and then you get an environmental catastrophe with the Dust Bowl in the Middle
Oh,
West.
that's
So you have
right.
people's farms blowing away. And
Yep,
then you have, if you've seen The Grapes of Wrath or read
yep.
the story, you have people just loading up every little bit of stick of furniture and heading to California. Or in my dad's family's case, finally, my grandfather got a job in Louisville, Kentucky with the Mack Truck Company as a bookkeeper. And my dad was the eldest of the three children. And he, as a teenager, had to load up the family car with whatever little bits they had, their clothing, and the family dog, and drive 100 miles in a heat wave when their car was breaking down. This was what people were living every single day.
Wow.
So Franklin Roosevelt gets through these massive Democratic Party majorities in the House and the Senate, one piece of what is called New Deal legislation after another. The New Deal is what Franklin Roosevelt, the populist, said to the American people who supported him. And by the time he's reelected in 36, he gets 2/3 of the popular vote and wins in a landslide over the Republican Alf Landon. And
Wow.
he says, I have a new deal for America. Well, certainly, if you are one of the 25% out of work, you've lost your home, you've lost your farm, you've lost your business, you'd like a new deal.
Oh, of
And so
course.
Franklin Roosevelt becomes the hero of those who support him. Those who don't, who tend to be the elites and the business people and the corporate people, don't like him because he is regulating their businesses and their corporations, and they call him that man. They can't even say his name.
They call
The
him that
Supreme
man.
Court,
That's so funny.
unfortunately, that man, the Supreme Court, unfortunately for the New Deal and Franklin Roosevelt and the big majorities in Congress, is made up of conservatives, primarily, at least a majority,
Mhm.
four of whom are very strict corporate lawyers, very conservative corporate lawyers. And as soon as businesses and agriculture start to question the New Deal legislation that wants to regulate them, those who are being regulated bring cases to the federal courts, and they work their way through the district courts and the courts of appeals that now do exist as freestanding courts. And they get to the Supreme Court on appeal, and the court accepts these cases. They have discretion over most of them, but they accept them because they want to strike down the New Deal legislation, because they're conservative and they're corporatist in their views of the economy. They don't think the federal government should regulate the economy or agriculture. And they sure don't think that a president, and certainly not this populist Democrat, big D and small d, Franklin Roosevelt, should.
Yeah.
So as soon as the legislation comes to them, they strike it down. And FDR is apoplectic because no one has the good graces in his first term to leave the court, and they won't even die. Okay, so he is so upset that when he wins in this landslide in 36, in 1937, he's inaugurated again. And by the way, when he's inaugurated the first time in 1933, I write about this in my book, The Priestly Tribe. He looks out but from the back of the Capitol, the east side of the Capitol, where now if you look out, you see the beautiful Supreme Court building, the Marble Temple, it's called. It's not there. It's only half built because the Supreme Court of the United States did not have its own building until the 1930s. And so
That's
I think
fascinating.
symbolically, not only does Franklin believe he's got all this power as president and the Congress is with him, it's not like he's just writing executive orders unilaterally.
Yeah,
He
yeah,
two
yeah.
branches of, and he gives a speech and he says to the American people in a fireside chat, he says, it's like the country is a wagon and the three branches of government are three horses. Two of us horses are pulling in the same direction, the president and the Congress. The court is pulling in the opposite direction, and that is not helping us.
Oh, wow. What great imagery there.
Isn't that great imagery? And remember,
Yeah.
this is on the radio. no TV. You can see him in the movies if you have money to go to a movie and see him in a newsreel, but you are only hearing his beautiful baritone voice. And my parents would my mother would say they lived in my other grandfather never lost his job as a machinist, but they lived in working class neighborhood with what is called a shotgun house, which is 4 rooms in a row. Front room, as my grandparents called it, 1 bedroom, a dining room, and a little kitchen. 3 children, 2 sleeping in the living room. I think my uncle slept in the dining room. And they would have a radio in the dining room, and they'd all gather around and listen to Franklin Roosevelt in this beautiful, confident, encouraging voice. So that imagery, everybody can picture that, especially my grandparents who had grown up in the horse and buggy era. So they can see it.
And Dr. Barry, if I may add, correct me if I'm wrong, back then when you say listening to the president, it's not like now where you switch the channel or you turn on your social media. There was not much else to do, and everyone did listen to the radio and the president, right?
Well, my great uncle, my mother's uncle, ran a tavern in this little Germantown section of Louisville. And so they were all Germans, and they imbibed and beer. And so if they weren't at home listening on the radio to the president, they'd be in the local tavern down the street having a beer, and they'd turn on the radio. Or Doris Kearns Goodwin, the historian, says you didn't even need to be inside listening because people would have no air conditioning at the time. If it was summer, their windows would be open. They might have brought a radio out to the porch somehow, or they'd have the radio on in a car. So she said you could just walk down the street and hear the president. So he is so angry that he says, all right, I've got an idea. I'm going to pack the Supreme Court. It's got 9 members at this point and has had since 1869, but it's Congress that can change that number. And I'm just worried that I maybe not be able to get this through Congress, but here's what I'm going to do. I'm going to propose that I think these elderly people on the court who won't die and they won't get sick and leave, they are too old and they're in their 70s. And the 4 main corporate lawyer types he called the 4 horsemen of the apocalypse.
Oh, boy.
And again, great image. And he said, I think the court is behind in its work because it's too old. And so he proposes to the Congress that for each justice over 70, since they aren't leaving, he will get to appoint a new justice up to a total of 15 members of the court.
Wow.
Interesting idea. And we heard this during the Biden administration because of Trump's appointments to the Supreme Court, getting 3 members on the court. So you heard, in fact, Biden created a commission to study adding members of the court. Didn't go anywhere, but we still think of that. People do. So one problem for FDR in this plan: 1, a majority of Americans never supported it. Nice. So even though he had won 2/3 of the popular vote in 36, a majority of Americans never supported it. They thought he was getting out of his lane of the presidency. 2, even newspapers that were known to be Democratic supporters, big D political party supporters, wrote editorials against it and said it was dictatorial. And some even compared him to Hitler, who had taken power at the same time FDR did in 1933. So those were 2 strikes against him. Here was the fatal 3rd strike. Chief Justice Charles Evans Hughes wrote a letter to the Senate committee that had jurisdiction over the court and would determine if this scheme might go through. And Charles Evans Hughes, the Chief Justice, wrote and said, we are completely up to date on our docket, on our work. We're not behind at all. Well, that was the main foundation and premise.
That means we're not old. We can do our job properly.
We may be old, but we're up to date on our work. And not all of them were old, just some of them. But the main thing was we're up to date on our work, and that knocked the props out from this plan. So interestingly, by this time of 37, we call it the switch in time that saved 9, 2 members of the court began voting pro New Deal. And then there were enough liberals there that they combined together that as New Deal legislation continued to be challenged, there were at least 5 votes to uphold it. And at about the same time, these 4 elderly corporatist conservatives started to leave the court, retire, and move on. So as my dear mentor here at University of Virginia, who was a specialist on the court, used to say, in the end, Franklin Roosevelt packed the court the old-fashioned way. People left, he got to put new people on, and by the time he died in 1945, he had placed all 9 members of the court, including the Chief Justice. But he replaced the Chief Justice in 1940 or so, about the time World War II was beginning in Europe. We weren't in it yet. And he saw the war coming. He thought, I should be bipartisan. He put a Republican in the Chief Justice's chair, Harlan Stone.
Really? Oh,
yeah.
Wow.
But the others were all New Deal Democrats.
Yeah.
So they were supportive generally.
So much has happened in the New Deal, and I'd love to ask more questions. But in the interest of time, I'm going to go to another important sort of epoch in our history. You can't talk about President Potus versus SCOTUS, if you will, without mentioning Watergate. Let's talk about that, if briefly, if possible.
My favorite topic.
Your favorite, so have at it.
I come of age. I come of age during Watergate. And my mother took me to see John Kennedy in 1960, campaigning in Louisville in October of that year when I was 4. And I was hooked on presidents and presidency and government. And I was reading children's biographies of Washington and Lincoln in 1st and 2nd grade. So this is all lifelong interest for me. And then by the time I'm in high school, I'm working in campaigns for senators and local party holders, party runners for county judge, and judges in Kentucky are elected. And so I'm working for judges. I'm working for governors in their races as a high schooler. I just couldn't wait to be a part of politics. And so wouldn't you know, in the midst of all of this interest in government and politics, Nixon and Watergate happens. So I'm glued to television watching the Watergate hearings, in the summer of 1973, which breaks open the story, because I'm sure you can fill in the details of the break-in by those who were working for the Nixon. It was called the Committee to Re-elect the President, had the unfortunate acronym of CREEP. And the CREEPs who were hired by Nixon supporters in this Committee to Re-elect the President, hired and paid those to go into Democratic National Headquarters in the Watergate Hotel, apartment, and office building on the river, on the Potomac River in Washington, D.C. And they were caught. They had been in there before planting bugs and listening devices, and they weren't working properly. So they went back in. These were bold people, and they went back in, and some of these people had ties to the CIA. And so that's how it all begins, and it starts into the court system, in the local courts of Washington, D.C. And the way it ends up in Nixon's bailiwick, he could have probably said, truthfully, as he tried to say, I didn't know about that. And there's never been any evidence that Nixon knew about the original break-in. Unfortunately, just after it happened, he begins to conspire with his White House advisors, his domestic advisor, his chief of staff, his White House counsel, a lawyer, to conspire to cover up. Wow. To cover up the crime. And now that they can't cover up the crime, they're going to try to cover up their relationship between the White House and CREEP, which was being run by the former Attorney General of President Nixon.
Wow.
So he couldn't hide the conspiracy except in the following way. Ever since FDR, as soon as there was technology to record conversations, in other words, tape recorders, we would call them, FDR started tape recording some of his conversations in press conferences. And every president did, but particularly Kennedy, Johnson, and Nixon tape recorded the most.
Not LBJ?
Yes. So let me back up. So after we have FDR using this technology. It's not very good. And so you don't have much from Truman or Eisenhower. But Kennedy decides that he wants to record his meetings and phone calls, especially during the Cuban Missile Crisis, because he knows that that is going to be a difficult decision. He had been really undermined by the military and the CIA at the Bay of Pigs in 1961. Mm-hmm. That was a failure for him. And so he wanted to record his meetings secretly. Others didn't know they were being recorded, except for his brother, Robert, the Attorney General, in case he ever needed proof that he did the right thing or that advisors gave him bad advice. Johnson carried it on even more with meetings and phone calls, and Nixon as well. So meetings and phone calls. So there's this body of evidence that is not known about in the Watergate scandal until the Senate Watergate Committee finds out that someone called Alexander Butterfield has installed this and known about it and constructed the process. And so he knows that Nixon has tape recordings of almost all of his conversations on the phone and in his office in the White House and in the office in the Executive Office Building. And so he is subpoenaed. Obviously, he doesn't want to reveal this, but he is subpoenaed before the Watergate Committee. And they say, are you aware that there were recording devices in the White House and the president's office? And you can watch this on YouTube. He almost all the color seems to go from his face. Or he just says, yes, I am aware. Because he's under oath.
Yeah.
He has to tell the truth. And so by this time, in 73, getting into 74, Nixon is declared by the federal courts where all of the president's men, Nixon's men are starting to be taken to court under criminal indictment, but they don't have the tape evidence. And so far, nobody knows about the tape until Alexander Butterfield spills the beans, as he has to.
Yeah.
And the problem is that Nixon has been declared an unindicted co-conspirator because the Justice Department has said through an opinion that presidents in office cannot be indicted criminally. That's their view.
Oh, okay.
So Nixon is not in court. He's not in court for the Watergate action or conspiracy, but his former attorney general is, his White House counsel is, his advisors, Haldeman and Ehrlichman are, and they are indicted for all of the things that they were doing around this conspiracy, around the actual break-in and the cover-up and the conspiracy around it, and abuse and misuse of the CIA and the FBI. So Nixon thinks, I'm safe as long as I can hold on to the tapes, and I'm not going to be indicted because I'm an unindicted co-conspirator according to the federal courts. So the courts come to him saying, you need to turn the subpoena. We need these tapes as criminal evidence in the criminal indictments and trials of your advisors. And he says, no, I don't have to do this because of executive privilege. Something Washington established, not in the Constitution. Executive privilege says that presidents can keep to themselves their papers, their recordings, their conversations, their letters, particularly for national security. So this gets to U.S. v. Nixon. The Watergate tapes case is handed down by the court in August of 1974 with 4 members of Nixon's appointees on the bench.
Oh, wow. 4 of them were his appointees.
4 of the 9 he appointed, including the Chief Justice, Warren Burger. One of them, William Rehnquist, who later on would become the Chief Justice. He's an associate at the time. He recuses himself because he had served in the Nixon Justice Department. So he says that would be a conflict of interest. That's all right. He steps aside. 8-0, including 3 Nixon appointees, rule against Nixon. And they say there is a power of judicial review that the president has as a precedent going back to Washington. It applies to military and diplomatic secrets to save the country's national security. We have no indication that what Nixon is wanting to say, covered by executive privilege, is military or diplomatic secrets. He must turn over his tapes as evidence in the criminal trials of his advisors and his former attorney general, who was the head of CREEP. With that, his own members, leaders of his own party in the Congress, go to the White House, led by Barry Goldwater, the senator from Arizona, who had run unsuccessfully for president in 1964. 10 years later, they're with Nixon, the leaders of his party in the House and the Senate, and they say, Mr. President, you will be impeached. That process is moving forward in the House, and you will be indicted by the House. We can't save you there. And when the trial happens in the Senate, as it inevitably will, you will be convicted and removed from office. You do not even have our votes. We will not vote not to impeach you, and we will not vote not to convict you. And I think one of the main reasons for Nixon then resigning, no other president has ever done that before or since, was that I think a president would not get his pension if he resigned. And so they said, this is what will happen. And Nixon announced a day or two after the Watergate tapes case from the Supreme Court that he was resigning his office. And it's worth watching. I can remember watching it and being tearful, just because the thing he wanted the most in his life was to be president. He had failed in 1960 against Kennedy, but he succeeded in 68, barely, against Hubert Humphrey because of the Vietnam War. And then in the landslide in 72, been reelected. And he didn't even need to do the Watergate.
That's the irony of it. Yeah.
That's the irony. So it's very sad. And that's when I think the only time you see the real Nixon.
Yeah.
He becomes tearful. He talks about his mother. Says, my mother is a saint, but no one will ever write a book about her. And one of my friends pointed out that Rose Kennedy's memoir, Rose, the mother of Jack Kennedy, our president, wrote a memoir that came out that year, and that Nixon always had an issue with the Kennedys.
Yeah, he did. I'm familiar with this story, not as familiar as you are, and I can't tell it as well as you have, Dr. Perry. But one of the things
sure you could. And could.
One of the things I always wonder is if Nixon had more political friends. He was known for making a lot of enemies. If he had more political friends, you always wonder whether or not he would have navigated this better, and he could have just sort of ignored the court and moved on and not given the tapes, but by then, not only he was legally in a corner, pushed to a corner, but he also politically was in a bad spot. Let's take a break here.
Just one last point. He had indicated he might not follow the court's ruling or order if they ruled against him. But he gives in and does his constitutional duty, I think, because of the delegation of Republicans who at that time had a backbone.
Yeah. Well, speaking of Republicans who had a backbone, let's take a break here. Okay. Stay with me and Dr. Perry as we get into the perspective. Dr. Perry, in the closing of our last segment, you said, back then, as in at the time of President Nixon, when Republicans had a backbone, and we don't really have to talk about politics, but we know that there's a lot going on with the Republican Party and their relationship with President Trump. Maybe they don't have a backbone. Maybe that's your view. But what I'm interested in is what's happening with the president and our court system.
Yeah, what's up with that?
Yeah.
We are, as you know, as someone who studies history, and same for myself, that they say history doesn't necessarily repeat itself, but it rhymes.
Yeah.
And I see rhyming between what is going on with the incumbent president and someone like Jackson, who metaphorically thumbed his nose at John Marshall, the Chief Justice, in the Worcester versus Georgia case, not so much because, as we said previously, that there was a direct order from the court led by Marshall to Jackson to do something, but a ruling of the court that would give certain limitations to what the federal government could do vis-a-vis the Cherokee in Georgia. And even if Jackson didn't literally say, well, Marshall has made his decision, now let him enforce it, that's how he viewed Marshall. And that's what we hear from the incumbent president right now. We also hear a lot about impeachment from not only the incumbent president, but the administration of the 47th presidency. We hear it from the vice president. We hear it from members of Congress that if they don't agree with a decision of a lower court, in the case of the district court that not only ruled, but made an order, a direct order to the Trump administration to turn planes around that were carrying Venezuelans to a super prison in El Salvador. And they were asked to turn, the administration was asked and ordered by the judge of the district court to turn the planes around because they did not have the power to do what they were doing. They not only didn't follow the order, but they are now talking about a need to impeach that federal judge and remove him, convict him and remove him from office. They are talking about the possibility of changing jurisdictions of the federal courts at the different levels. And Mike Johnson, the Speaker of the House, most recently even talked about the possibility of abolishing certain levels of the court system in the federal system, which, by the way, Congress has the power to do, except for the Supreme Court, which is established in Article 3 of the Constitution.
I haven't asked you if you're a Republican or a Democrat, and that question is completely irrelevant. You're an American. You're a historian. How does that make you feel?
So thank you for not asking me my personal politics, which of course I have, as somebody who's really interested and have been since, as I said to you, my mother took me to see John Kennedy when I was 4. So I've literally been interested in the presidency my entire life. I won't say how long that's been, but you can do the math. And in any event, first of all, as a professor, I know there are many people who think professors proselytize in the classroom. I never had a professor, and I majored in political science as an undergrad, and I went to Oxford and did my master's work, and I did a PhD in government at the University of Virginia. I knew sometimes what my professors' politics were or their ideologies were, but I didn't find them to engage in proselytizing their positions and try to convert us in the classroom, which I know that people think professors do, and maybe some do. The Miller Center, where I am based now at the University of Virginia, after doing teaching for a quarter century of undergraduates at 2 different institutions, the Miller Center is a nonpartisan organization that was founded by Dwight Burkett Miller 50 years ago. We're celebrating our 50th anniversary this year. He was, I suspect, a conservative Southern Democrat from Tennessee, had ties to the University of Virginia, and in the 1960s and 70s was worried about our country and our constitutional and governmental system because of the riots in the streets, the civil rights movement, eventually the women's rights movement, the war in Vietnam, the violence, the assassinations, and then Watergate. And so he founded the Miller Center with an endowment that happily we've been able to advance. And he wanted us to be at a university to take advantage of the expertise of professors in their fields, particularly history and political science. But he didn't want it to be completely under the thumb of a university. He probably worried about liberals at universities 50 years ago. We maintain our nonpartisan approach to the study of the Constitution, the presidency, and public policy. I am the co-chair of the Presidential Oral History program at the Miller Center that is almost 50 years old. And we started interviewing, I was not there 50 years ago, but we started interviewing, or the Miller Center did, the Gerald Ford administration, and we've done oral histories of every presidency and sometimes the presidents themselves, no matter if they're Democrats or Republicans, from Ford I'm finishing up the Obama project right now of his 2 terms. We've interviewed almost 80 members of his administration, and a colleague of mine who co-chairs the program with me is starting the Trump project, and I'm starting to work on that as well. So that will be of the first term. So what I see, though, and what really worries me, back to the original heart of your question, is that I am an American, as you say.
Yeah.
I had a great uncle who fought in World War I in Europe. My dad was a
Wow.
World War II veteran who was in the Italian campaign in 1944-45. My brother is a Vietnam veteran. I am the first in the neighborhood every federal holiday to put my flag out and sing with gusto at athletic events, the Star Spangled Banner. So I guess by some people I'm considered a conservative. But I also know that I think as a Catholic, I was raised on social gospel. So in that sense, I'm probably viewed as a social liberal, help those less fortunate.
Yeah.
And so as someone who loves our Constitution and loves our government, and particularly loves the presidency as an institution, by the way, I should report, I serve on the board of directors of the White House Historical Association. And it was founded by Mrs. Kennedy in the early 60s to preserve the history and the actual physical structure in and out of the White House. So
And
I
that's
get to.
still functioning.
Oh, yes. It's a nonprofit 501c3 private organization with an endowment, thank goodness. But so
Oh,
it's not
wonderful.
supported by the government at all. It's all by private donations. And we work very closely with whatever president and first lady are in the White House to
After
help
the
them preserve. So again, bipartisan is how I see it. And I'm so lucky now because of that role. I've gotten to go to 2 White House dinners, 2
How
holiday.
wonderful is
Yeah. And
that?
so I call it breathing their air.
Yeah. By
When
the
I
way,
go
the White
history
House,
places.
I want to just add this,
Yes.
the White House Historical um, Association Society actually sent my daughter a gift for her artwork that she sent to the White House.
Oh,
So this is
oh, I
so
love that.
beautiful. I
I
will have to
love
tell
that.
her
And they
about
have a
this.
wonderful website. They
Yes.
have wonderful art, I would call them reproductions of artifacts in the White House.
Yeah.
Just any president you like, or any form of the White House that you like in its history, books, journals written for the general
Wonderful.
public.
Yeah.
And we just opened last September, we call it the People's House because we view the White House as the People's House. This is located at 1700 Pennsylvania Avenue. It is now, if you go to Washington or if you go to its website, but particularly if you're in Washington, if you can't get into the White House, or even if you have been, it's an interactive experience with White House history.
Look forward to visiting it. I want to go back to the question that I asked you, though. How do you feel?
I feel worried because of that long explanation of my patriotism and my love for the American Constitution, our founders, our past presidents, and our institutions, and the fact that I actually have served in some capacity in all 3 branches of government, from internships to a fellowship at the Supreme Court in the mid-90s. I just love these institutions. And so any political or partisan action that would weaken these institutions in the eyes of our countrymen and women or the world is worrisome to me. And I will say that as part of my job at the court, I spoke to 3,000 visitors from 70 different countries. And I was so proud to do that. As Rehnquist would call the court, as the jewel in the crown of the American judiciary. And I think it's the jewel in the crown of our Constitution. And I was so pleased that John Roberts, our current Chief Justice of the United States, and note, that's the title of the chief. It's not Chief Justice of the Supreme Court, it's Chief Justice of the United States, in a very unusual move, spoke out against this current administration's talk of impeachment. And he said, in a nutshell, when you disagree with a decision of a court, the way to counter that is through the judicial system Or if you're in Congress or a state legislature, you can pass a new law or a different law. You can even try to amend the Constitution. If you're a president, you can hope for an opening on a court. You can shape the courts through your appointments. But disagreeing with a court and countering it is not through the impeachment process. And it not only concerns me that that lowers the view of how the American people view the Supreme Court. And right now it is at its lowest approval rating in its history. That is since those polls have been taken. But I worry about the safety of our judges and justices.
That's sad that you would worry about that. Not that your worry is sad. It's sad that that's where we are.
Yes, and I have a dear friend here in Charlottesville who's a neighbor of mine who's a federal judge, and when I drive by the house, I look to see, are the lights, they have good lights and good security system in the federal building here in Charlottesville. Is it protected? Before social media and before the focus on the court to the extent that it is today, I once was in National Airport picking up my parents who were arriving from Louisville and Washington, and I saw Chief Justice Rehnquist walking through a National Airport with no security.
Wow.
And no one knew him. And I would see retired members of the court, like Justice Powell, they keep their chambers at the court even when they are retired if they want them. And I'd see him walk through, go past visitors, go past the cafeteria, go past tourists, and they had no idea who he was. I'm not sure that would be the case now. And that's why it worries me. And we've had attacks on, and we have had people threaten both Democratic appointed and Republican appointed judges. And so, unfortunately, those threats have been bipartisan. I worry more after January 6th of 2021, when a friend called me to say, Barbara, they, meaning protesters, they're in the Capitol, they're on the floor of the Senate and the House. I said, you must be wrong. That can't be right. Because to me, that the court and the White House are sacred, my civil religion. They are sacred places to me. And to see what those
no matter your party.
Yeah. Yes. It doesn't matter who's serving in them at any particular time. I may have disagreements, but those buildings are sacred spaces to me and should be viewed and treated that way.
Let's end our interview by me putting you on the spot. Do you have a message for the American people? Any particular lessons you want to impart?
I do. And it's what I would say to a group of students, or I speak to a lot of public audiences, and I do a lot of teacher institutes for the Gilder Lehrman Institute of American History. And that is, we have been through difficult times before. Now, if you agree with what is happening now in our system, good for you. You have voted to have a president we currently have in the White House. You have voted to have certain people in Congress and certain people who agree with you on the court. And that's the way the system should work. That's our democratic system. What we don't want to have are violent reactions of people. We don't want to have threatening actions of people. And we don't want to get into what I would compare as the next worst situation to, for example, January the 6th of 2021, and that was the Civil War. Heaven forbid that we should ever get to a time when our own citizens are fighting our citizens, countryman and woman against countryman and woman. So keep the faith, I say. Our Constitution is still strong, and I hope it remains that way. And do everything you can to teach your family and students and friends about our system, about civics, and to be civil in conversations with each other. And even when we protest in the street, as Chief Justice, let me back up, as Justice Abe Fortas used to say in the 1960s when he was on the court, civil disobedience needs to be civil.
Yeah, that's a wonderful message. Dr. Perry, thank you so much for educating me and our audience. And to our audience, if you know of any history that could provide more perspective from the past on this subject, please share it with us and tell us what's your perspective. Thank you so very much.
Thank you, Adele.